Good afternoon, all. Welcome the Honorable Judges of the Madras High Court. Welcome the Honorable Judges of Mopasi Judiciary, all the senior counsels, and my dear young friends. And we are delighted to have Mr. Gautam Bhatia, one of the very famous and popular personality in the field of law. And his articles are much loved, and his blog is very famous. And one of my friends told me that he won't leave the chamber without reading his blog in the evening. So that is the popularity of Gautam. I don't believe in flattery as a matter of fact. And the specialty with Gautam is he has got popularity pan-Indian scenario. It's very special. And may I now request Mr. Suhrit to brief the participants about Mr. Gautam before Mr. Gautam takes over the podium. Suhrit, you are welcome.
Sure. So I think Mr. Srinivas Raghavan's already done a fair job of the introduction, but I mean, for many of us who are from Tamil Nadu and from the rest of the South, we know Gautam Bhatia through his trenchant and incisive articles in the opinion pages of the Hindu newspaper. But Gautam's scholarship and range of interests are diverse and manifold. He's presently a DPhil candidate at the University of Oxford. He graduated from the National Law School in Bangalore and then read for the BCL and the MPhil at Oxford and for an LLM at the Yale Law School. He is the author of two seminal works of legal scholarship. The first being Offend, Shock or Disturb, which is a comprehensive book on freedom of speech and expression under the Indian Constitution, which was published by Oxford University Press in 2015. And more recently, the Transformative Constitution, which was published last year by HarperCollins, which will, of course, be the subject of the discussion today. Now, both these books and his other articles, as well as his blog, as Mr. Srinivas Raghavan mentioned, have reached a wide variety of audience, and it's also been cited, and both these books and a number of his articles have been cited by the Supreme Court and various other high courts, including the Madras High Court. Interestingly, Gautam has also written a work of speculative fiction, which will also be published by HarperCollins and which will be out later this year. So as I said, the breadth of his interests are quite staggering. Gautam also practiced for 4 years as a lawyer in Delhi. He was part of the legal teams that challenged the constitutional validity of Section 377 of the IPC, which of course prohibited same-sex relations, and the Aadhaar project, which is India's national biometric identification scheme, among other cases. So I take great pleasure in inviting Gautam on behalf of the organizers to address all of us. And on behalf of all the listeners, I'd like to thank him for having taken the time out to speak to all of us today. So over to you, Gautam.
Welcome all. Mr. Gautam, you can now take over the forum. Thank you.
Thank you so much, Mr. Raghavan and Suhrit, for that very, very kind introduction, and thank you to you and to the Madras Bar and to the Honorable Justices for inviting me to talk about the Transformative Constitution. It's particularly significant for me that I'm addressing members of the Madras Bar and the Honorable Judges of this High Court, because as someone who's had a long-standing interest in civil liberties and civil liberties as an aspect of transformative constitutionalism, the reputation of the Madras Bar has been a sterling one, going back in time to the very beginnings of our constitutional democracy. So, for example, in July 1949, the very first meeting of the All India Civil Liberties Conference took place in St. Mary's Hall in what was then Madras and is now Chennai. The Madras Civil Liberties Union, that was a widespread body that had contributions not just from lawyers but from representatives of workers, famous people like S. Satyamurthy, K. Santanam and so on, was extremely active at the time that the Indian Constitution was being drafted. There was a very famous judgment of the Madras High Court's full bench in 1948 called Naidu versus Inspector of Police, where the full bench actually held that even though legislation indicated the contrary, the court was entitled to review and set aside preventive detention orders for compliance with CRPC provisions. At around the same time, the local chapters of the Madras Civil Liberties Union, which were spread across the state, were producing detailed reports on the misuse of Section 144, the then old 144, that the police were using to suppress all kinds of peasant struggles. That, of course, is something that still is with us. And we've recently had some very good judgments of the Madras High Court on Section 144. So it's a tradition that's continued. I remember being in law school and studying the V.G. Rao judgment. And after graduating from law school, being involved in some civil rights cases, V.G. Rao has become that one judgment that we always cite. It's always there in our written submissions before the court, because long before the Supreme Court actually developed these ideas of proportionality as a test for reviewing fundamental rights violations, the word was used in the V.G. Rao judgment. And of course, we all know the judgment itself. It was only many years later that I found that Mr. V.G. Rao himself was a very famous labor lawyer who worked in the Madras High Court. And I'm sure that is very well known to members of the Madras Bar. But to someone who grew up in Delhi, who went to law school in Bangalore, it was quite a discovery that the person V.G. Rao, the person behind that famous case, was a very famous and legendary civil rights lawyer in what was then Madras. And of course, A.K. Gopalan, the case that we all study the Supreme Court judgment. But it's worth remembering that the judgment came up from the Madras High Court, and the Madras High Court had held that Mr. A.K. Gopalan actually was entitled to habeas corpus remedies. And so I think of the Madras Bar and the Madras High Court as one of the bars and the high courts that really grasped this whole idea of the transformative constitution, and the idea of the constitution as being an instrument or a terrain on which state power and social power could be challenged on behalf of the individual, on behalf of the vulnerable and the marginalized people. The Madras High Court and the Madras Bar grasped that core idea very early on. And we've seen that of late as well in orders around defamation, in orders around Section 144, in questioning the government's steps that were being taken to transport migrants and so on. So it's that tradition that has always been there. And that's what it makes it such a privilege to talk about transformative constitution in this forum. So keeping that tradition in mind and keeping in mind the fact that transformative constitutionalism is something that has been lived in a forum like this, I want to begin by bringing a perspective from my own language, which is the Hindi language. And in Hindi, the word constitution, the word for constitution is samvidhan, and the root word of samvidhan is another word called vidhi. And what the word vidhi means, among other things, is that it refers to a way or to a path that you must take if you want to accomplish something. So you must go along a certain path, you must go down a certain route to get to your destination, no matter how noble the destination is. And so when you think of the constitution in terms of this word vidhi, what you understand is that no matter how desirable the goal is, how noble the end is, there is a way that you must follow to get there. And along that way, along that path, you have some signposts. These signposts embody some values or principles like individual rights, human dignity, equality, pluralism, diversity, a respect for our federal structure, and so on. And I think that what it means to be a constitutional republic is that we don't view the destination as being separate from the path that we must take to get there. And the relevance of this, I think, is reflected in many of the debates that we have been having over the last few months, before, of course, COVID-19 came and displaced everything else from our mind space. And I hope on that note, everyone is doing fine in the lockdown. And I hope that I've heard that it's been difficult, but I hope that soon we can get beyond this and be back to normal. But I think that if you look at the debates that we've been having, the constitutional debates over the last almost a year now, it reflects these basic ideas. So whatever we might think of the content of what was Article 370 of the Constitution, whatever you might think of the desirability of its existence or the need to remove it, and there could be many views on that, the really key question that arises is that could such a far-reaching alteration to the federal structure be made at a time at which that state's own elected assembly did not exist because it was under governors and presidents' rule? Could such a change be accompanied by the detention of around 3,000 people and the shutdown of communications within the state? The latter part, of course, was challenged in the Supreme Court in a long-standing litigation in which, full disclosure, I was involved in. And these were the arguments we tried to make, that no matter what the goal and how noble the goal is, you cannot shut down the communications system of an entire population, a majority of which are completely innocent of any wrongdoing, just to ensure that that goal is fulfilled. Now, of course, there are some who argue, and many eminent lawyers among them, that when your goal is so important, whether it is integrating the state of Jammu and Kashmir into the Indian Union, or more lately, whether it is fighting COVID-19, if that goal is so important, then a few infractions along the way don't really matter. They are subsumed into the importance of the goal. I think that the Constitution, as embodying the idea of Vidhi, and the Constitution as a transformative document, says otherwise. And I think that it is precisely in addressing and assessing these arguments that it becomes important to understand what that path is that the Constitution insists upon, and what those signposts are along the way, what they mean, and why it matters. And it's here that the idea of the transformative Constitution becomes important, because words like liberty, equality, free speech, federalism, and so on, these words did not drop from the heavens. Each of these words that we find in the Constitution has a history to it. And this is a history of struggle, a struggle against injustice, a struggle to achieve a certain kind of freedom. And it's only in understanding the nature of that struggle can we understand what these words in the Constitution mean, why they matter, and how we should interpret them when we are dealing with specific cases, at the bar. So in that light, what is this history that we are talking about? Now, there is one school of thought that denies to the Constitution any transformative character. It holds that the Constitution is an instrument of continuity. It views the moment of constitutional framing as simply a transfer of power. This school of thought tells us that the Constituent Assembly, after all, was established under colonial British law. It tells us that 75% of the Constitution was lifted from the colonial 1935 Government of India Act. Most importantly, it tells us that many of the most repressive provisions from the colonial times, provisions for preventive detention, for emergency powers, ironically, two of the precise provisions that have been at stake in all these recent controversies, and many more, were carried over lock, stock, and barrel into the new Constitution. In the Constituent Assembly, there were those who rose to oppose this. There were those who warned that what the new Constitution was doing was simply replicating the colonial structure. But they were told that that was then, and this is now, and that an elected government would never misuse the legal framework. And on that argument, these provisions were retained. And so we are told, above all, that the Constitution was an instrument of continuity. And of course, this is not a mere academic dispute. Again, the use of President's rule to alter the constitutional structure in Jammu and Kashmir would be on a much firmer footing if all these constitutional provisions do is to replicate the same sweeping executive powers that were once afforded to an old colonial regime. But this understanding of continuity, that was not the understanding that the Madras High Court took in 1948. It wasn't the understanding that A.K. Gopalan took when he challenged his detention before the Madras High Court. It wasn't the understanding that V.G. Rao took when he took his case all the way up to the Supreme Court. These lawyers and these judges had a much broader and a much more expansive understanding of the Constitution and of constitutionalism. And that is the understanding I want to advance and defend as a correct understanding. Because in my view, we unduly constrict our vision of the Constitution by limiting ourselves to the text of the document and the specific debates that led to its framing and the political instruments that preceded it, such as the Karachi Resolution of 1930. Because there is a broader, deeper history to the words that finally found their way into the Constitution, those signposts I was referring to earlier. And that is a history of struggle. Because over the years in the colonial period, Indians responded to injustice, political, economic, and social injustice, by articulating a vocabulary of rights, of freedom, and of equality, and of human dignity. The great civil rights lawyer K.G. Kannabiran, in a passage from his book, The Wages of Impunity, sums this up beautifully and perfectly. And he writes, and I quote, "A constitution framed after a liberation struggle or a struggle for independence is like poetry, emotion recollected in tranquility. There cannot be and there should not be two social histories, one for political theorizing and another for legal theorizing. The people who met in the Constituent Assembly were not mere technicians who had gathered there to prepare a handbook for running the government. They had participated in the struggles, and short of holding elections, every effort had been made to give their gathering a representative character." Kannabiran points out, therefore, that there is a social history that underlies the Constitution, a history that goes beyond the nationalist movement and the Indian National Congress that dominated it. It is a history you will find in the most unexpected of places. For example, you find it in Bankim Chandra Chattopadhyay's Samya, a text from 1870s, that talks about structural and institutional inequality on gender, economic, and caste lines, far before that concept became prevalent in Western academia 100 years later. You find it in how Ambedkar articulated the idea of a right to public spaces during the Mahad Satyagraha and the temple entry movements. You find it in Motilal Nehru's speech about executive overreach in 1921. And it feels like he's speaking to the present when he says that the executive cannot engender a sweeping crackdown just for the crimes that may have been committed by a few people. And once you expand your gaze to this broader constitutional canvas, this broader constitutional canon, you find, I believe, that the Constitution was meant to be transformative in two ways. First, it was a politically transformative constitution. It marked a transformation from the colonial regime that viewed the Indian people as subjects to be governed, administered, and when need be, controlled. From there, it went to a republican democracy that viewed people as citizens. Citizens who were entitled to demand accountability from the government. Citizens who had rights against the government. Rights to free speech, association, movement, and so on. In South Africa, a country that endured a similar transition from authoritarian rule to Republican democracy, this shift is summed up beautifully. They call it a shift from a culture of authority, where authority was answerable to none for what it did, to a culture of justification, where every state action that impacts citizens' rights had to be justified to them. And they, in turn, had the right to disagree, to protest, and to challenge it in all forums available to them. So when we think of internet shutdowns, when we think of communications lockdowns, all these issues, what we're looking at is the exercise of a culture of authority, where the channels through which people can object or even engage with a decision that directly impacts the entire structure of life is cut off from them. That's one way of looking at it. And so this politically transformative character of the Constitution is, I think, what you see in those Madras High Court judgments, in A.K. Gopalan, and of course in the V.G. Rao judgment. That's the first sense in which the Constitution was meant to be transformative. But I think that the Constitution was transformative in a deeper sense as well, because it sought to transform not only the relationship between the individual and the state, but also to transform society itself. And this is because, unlike their counterparts in the West, who viewed the state or the idea of the state as a monolith, as a single source of power that needed to be controlled, the framers of the Indian Constitution understood that apart from the state, social institutions and social structures could also impact freedom, equality, and dignity. So it wasn't the case that if you constrained or controlled the state, the residue that would be left over was human freedom. That is a dominant way of thinking in the US, in countries like that. And in 1946, when he wrote a brief note to the Fundamental Rights chapter, Ambedkar pointed out that this was the dominant view of thinking. But as he also went to point out, this was a very incomplete and insufficient way of thinking, because it was equally essential to pay attention to the way in which institutions like gender, caste, and so on created hierarchies and unequal power relations. And that the project of constitutionalism was to interrogate and undermine those hierarchies in an attempt to achieve genuine equality and freedom. So this was a project of democratization that went beyond simply the public sphere, the domain of government, governance, officials, and so on, but democratization that addressed what we think intuitively of the private domain, that ought to apply the framework of rights to private relations, private spaces, private institutions. And this was contained in what we define as the Constitution's horizontal rights provisions, that is, rights applicable between private parties and not the state. Article 17, for example, prohibits untouchability. Article 23 prohibits forced labor. Article 15, Clause 2 guarantees non-discriminatory access to shops, restaurants, hotels. And if you look at the history of this provision, Article 15.2, you will find that it was essentially an anti-boycott provision. It was meant to defeat the social boycott, a process through which large sections of society were repeatedly denied access to some of the basic goods and services that are necessary to sustain a decent life, and indeed were kept segregated physically, economically, culturally, and socially to keep them subordinated. And so we often think of the golden triangle of the Constitution, right? Articles 14, 19, 21, as being that golden triangle that contains the heart and soul of the Constitution. All those rights are about political constitutionalism that engages with how the state cannot violate an individual's rights to freedom, dignity, equality, and so on. And I would suggest that 15, Clause 2, 17, and 23 is the second golden triangle that actually applies the same ideas, the same frameworks, the same concepts, but between private parties, and prevents social institutions from violating those same rights. And that's a way of understanding the Constitution's transformative nature in its second, deeper, more far-reaching sense. Now, having said that, and having outlined this idea, in the second half of this talk, I want to focus on a case study that I think exemplifies this idea of the transformative constitution. It's one of the most fascinating and indeed moving case studies that I have come across. And I think it's a story that has just about everything in it. It's a story that begins in the late 19th century, in the 1880s. Rukhma Bai was a young woman who at the age of 11 was married off to an older man called Dadaji. Rukhma Bai's parents were dead and she was brought up by her uncle who educated her. She did not live with Dadaji and he never sought her out either. However, when Rukhma Bai turned 18 and stood to come into a substantial inheritance left to her by her parents, Dadaji suddenly woke up and realized that he was married all these long years. So he asked Rukhma Bai to come and live with him. Rukhma Bai naturally refused to do that. At this, Dadaji went to court. He invoked something called the Restitution of Conjugal Rights, the provision that all of you would be intimately familiar with over the course of the years. Ironically, this provision is a colonial implant that had no origin in Indian family law. It was transplanted from the 1865 Matrimonial Causes Act in England. There was no equivalent in Hindu law. So the restitution of conjugal rights is a provision that requires that if one spouse has unreasonably withdrawn themselves from the company of the other spouse, then a court must pass a decree requiring the former to go back to the latter, hence restitution of conjugal rights. Under the provision, the courts would determine if the withdrawal was reasonable or not. Now, Rukhma Bai defended herself in court, and much to everyone's shock, she won the case at first instance. The single judge of the Bombay High Court hearing the case, an English judge called Justice Pinney, held that he would not order this woman to go to a house she had been married into at a time when she had been so young and effectively unable to provide any meaningful consent. And you can see here in a very incipient form the first idea of why consent matters, why the individual matters, and why rights matter beyond the state. Now, Justice Pinney's judgment led to a huge backlash. It was argued that the English, with their Western notions of rights, were unduly interfering with the sacred domain of family, community values, and so on, an argument that might seem remarkably familiar in 2020. This is an argument that's as old as the hills, that institutions such as the family, the home, the community are immune from civil law, from constitutional rights, from ideas of freedom and equality, because they belong to that private domain where the state's writ may not run. But perhaps what is most fascinating is that this backlash did not go uncontested. Indeed, the response was led by Rukhma Bai herself. In two anonymous letters to the Times of India, it still existed back then, titled Letters from a Hindu Lady, Rukhma Bai set out an eloquent and impeccable argument for how marriage imposes very different obstacles and barriers upon women as opposed to men. Rukhma Bai, of course, did not possess the conceptual vocabulary that would be developed many years later by feminist scholars. But nonetheless, what we see in her letters is a clear understanding and a clear articulation of the relationship between principles of equality and institutions such as marriage. And Rukhma Bai was supported by many prominent social reformers of her own day, men and women both, who, drawing from the writings of Mary Wollstonecraft and John Stuart Mill, articulated a language of rights, of freedom, and of inequality and equality that applied within and against institutional structures such as marriage and the family, where the state was not involved at all. Now, you will not find these arguments in political philosophy treatises or textbooks, which is the model of scholarship that we have long become accustomed to. You will find them in memoirs, in letters, in epistles, in records of public debate, in letters to the editor, and so on. Because it was in these forums where Indians articulated these ideas that the transformative canon of constitutionalism sprung to life. In letters like what Rukmabai wrote herself to the newspaper, setting out her position in this context. This, however, was not enough. The appeals bench of the Bombay High Court reversed Justice Vinay's decision and held in favor of Dadaji. Now, Rukmabai did not give up the fight. She appealed to the Privy Council and to Queen Victoria. But at this point, Dadaji probably realized that it wasn't really worth the effort. So he entered into a settlement with Rukmabai and dropped the case. And Rukmabai, interestingly, went on to become one of the first female trained doctors of India. So the story had a happy ending, even though the case did not. But now fast forward 100 years, from the 1880s to the 1980s. And this story now brings us to the High Court of Andhra Pradesh, as it was then in Hyderabad. This case involved another young woman called Sarita, who at the age of 16 was married to a man called Venkat Subbiah. They did not live together. Over the next 5 years, Sarita became a famous and popular actress. And then, much like Dadaji, Venkat Subbiah suddenly woke up and realized that they'd been married all these years. And like Dadaji, a century before him, he asked Sarita to come and live with him. Like Rukmabai, Sarita refused to do that. And like Dadaji, Venkat Subbiah filed a suit for restitution of conjugal rights. Like Rukmabai, Sarita defended herself in court. But that's where the paths diverged, because Sarita had something Rukmabai did not, which was the Indian Constitution. Sarita argued for the first time in constitutional history that the provision allowing for the restitution of conjugal rights was unconstitutional. She argued that it infringed upon her right to privacy, her right to take intimate and private decisions on her own without coercion, either by the state or by any other private party or institution. And Justice Chaudhary of the Andhra Pradesh High Court agreed with her and struck down the provision as unconstitutional. Now, it's worthwhile here to take a pause and step back for a moment. If we think about how the concept of privacy evolved as a legal concept, starting in the US at the end of the 19th century, we find it took two forms. The first form was the privacy of spaces. Contained in the old chestnut, a man's home is his castle, the privacy of spaces held that there was something sacred, something morally salient about spaces such as the home. The home was the threshold beyond which the state could not come. And of course, what happened beyond that threshold, what happened inside the home, was nobody's business. The second form of privacy was the privacy of institutions or relationships. According to this form, there was something morally important about relationships such as marriage, family, and so on, that had to be insulated from state interference. For example, in the United States, there was a law that prohibited married couples from using contraceptives. The US Supreme Court struck down this law on the basis that what happened between the marital relationship was not the state's concern. Another example is the Irish Constitution, a document from which our own framers borrowed heavily. And the Irish Constitution is an article that sets out the family as the fundamental unit of constitutional concern, Article 41. But Sarita was articulating a very different idea of privacy, an idea that came into direct conflict with the privacy of spaces and the privacy of relationships. She was seeking privacy for herself, an individual, in and against these spaces, the home and relationships, the family, the marriage. She was making an argument that Rukmabai made a century ago, but now with the constitution on her side. And this was an argument Justice Chaudhary found compelling. He held that an individual did not lose their right to privacy on entering into the marital union, and the restitution of conjugal rights effectively transferred some of the most fundamental and intimate decisions and choices away from the individual, and therefore it was unconstitutional. Now, Sarita and Justice Chaudhary's arguments will of course be familiar, because for decades scholars have argued that privacy as traditionally understood is blind to the hierarchies, the inequalities, and the relations of power that exist within what we understand as private spaces, and thereby end up perpetuating and entrenching those power relations in a manner that severely curtails freedom and equality. And for us, those arguments had their origins in one woman's battle in the 1880s and came to fruition a century of freedom struggle and a constitution later. But this story also did not end here. The same year, 1983, the Delhi High Court was also considering the same question, the constitutionality of the restitution of conjugal rights. The Delhi High Court came to the opposite conclusion. It decided to uphold the provision. And what is most interesting is the language it used. It observed that cold constitutional law could not be allowed to enter the warmth of the home, and that doing so would be like bringing a bull into a china shop. Now, the issue of temperature differences aside, this is exactly the argument made 100 years before in the backlash to Justice Binney's decision, that the space of the home and the family has its own governing principles. Its warmth fundamentally at odds with the coldness, the objectivity perhaps, or the detachment of law and of constitutional rights. And a couple of years later, the Supreme Court, when called upon to resolve the conflict, went with Delhi High Court and also upheld the provision. But that story is not over either, because in 2017, in the famous Puttaswamy judgment, which we all know about, a 9-judge bench of the Supreme Court was asked to rule upon whether privacy was a fundamental right under the Indian Constitution. In answering that question in the affirmative, the court also went to the question of what precisely was meant by the right to privacy. And it came down strongly on the side of privacy being an individual right and not a right that was accorded to spaces or to institutions. Indeed, writing for himself and 3 other judges, Justice Chandrachud devoted pages to examining this whole critique of privacy that we have been talking about, and held that any conception of privacy would need to acknowledge and address and take into account the inequalities of power that exist in private spaces. In his concurring opinion, Justice Charameshwar observed that with this judgment, the whole question of restitution of conjugal rights may have to be reopened. And that brings us to the question that is the resurrection of Justice Chaudhary's transformative vision on the cards. Only the future can tell. But there we have it. In the conflicting judgments of the Andhra Pradesh and the Delhi High Courts, what is represented are 2 competing visions of the Constitution. And it's not for me to say one is right or one is wrong. There is one I agree with, but it's a question of what vision you find more persuasive, given the history of our Constitution, our freedom struggle, the stories of Rukmabai and stories like that exist. They are legion in our history. Which vision is more true or faithful to the Constitution? One is the transformative vision that the Andhra Pradesh High Court accepted. The other is a more conservative vision that the Delhi High Court accepted. One is a more emancipatory vision. One is a vision that's focused more on control. One is a vision that interrogates and questions power wherever you find it, in the state or anywhere else. And one is a vision that preserves that power as it was before. In many different ways, these are the questions we face today. And the Constitution is one terrain upon which those questions are debated. In the courtroom, yes, that's a very important site. But as we've also seen far beyond the courtroom, in public debate, in our daily lives, in the institutions that we participate in the relationships we have with others and with ourselves. And I suggest that the stories of Rukmabai and Sarita point us to the direction in which we may answer these questions, and indeed the directions with its signposts in which the Constitution of India does answer them. And so with that, I will close and I will open it up to questions and answers and a discussion. And I hope this was interesting.
Thank you, Gautam. To put it in one word, I would say it is rather very elucidative. I'm leaving not so much of doubts about what could be the transformation which we expect or hope for the country to in the matter of constitution. I have one personal question, Mr. Gautam. See, all the articles are subject to a reasonable restriction, we know well.
Yes.
So if the constitution makers are very clear of what could be the general rule and what could be the exception by making pigeonholes,
yes,
there is no hope for any transformation or any evolution of law.
Yes.
So I now have only one question to you.
Yeah.
If you are given to fix the parameters of the exception to Article 21, what could be the predominant exception to Article 21 in your ideas?
Yeah, no, so I think that I would answer this in the way the Supreme Court has recently, which is that there is a doctrine of proportionality, which says that, of course, we all agree that rights can't be absolute and there need to be restrictions. The question is that what framework do you apply to judge if those restrictions are reasonable or not? Now, what proportionality does is something very interesting. It has 4 steps, and each step is relevant. The first step is that there must be a law that is legitimate. It's a legitimate aim, right? So Parliament must pass a law, our representatives must debate, our elected representatives must debate, and they must decide at the first instance what the parameters are for a legitimate purpose. That's the first step. That's a very basic step. The second step is that there must be a rational relationship between the purpose and the means you're choosing. And we know this from Article 14, rational nexus, right? So for example, you say, I want to stop crime and I will imprison everybody above 6 feet. Right? There is no rational connection between those two, right? So the test, the government's restriction must pass that basic test of rationality.
Right.
Now, the third step is the really important one. And this is something called necessity. And it's summed up in the words of a famous German scholar when he said that you can't use a cannon to shoot at sparrows. And so the idea is, right, that you want to achieve a certain goal. And to achieve that goal, you need to restrict some rights. You can't achieve it without doing that. But you have measures A, B, and C to achieve that goal. Measure A infringes upon rights to a certain extent. Measure B less so, and measure C even less. You as the government then pick measure A, despite the availability of alternatives that are less restrictive. Then at that point, the court strikes it down. So again, just to give you an example, this whole debate over Arogya Setu, and I don't want to go too much into it because that's a sub judice case and all of that. But there is a big debate over whether if you have a contact tracing app, do you centralize the information or do you decentralize it? Right? Is it just staying on the phone or is it going into a database? Now, if you look at research that has been taking place across the globe, the consensus now is that a decentralized app will serve the purpose of contact tracing while infringing privacy less. So you have 2 options, centralized, decentralized. One of them, both of them serve the goal. One of them is more protective of rights. Then the government has to pick the former one, right? And so what this step does is basically it forces or compels the government to come to court and say, look, this is the basis on which we have picked this method to achieve our goal. And we have considered all the alternatives. And we have found that this is the least restrictive alternative. And the court can ask, look, okay, fine, show us how that is the case. And if the court is convinced, then the court can say, fine, you have passed, like this is fine. If not, then go back and pick the less restrictive one. And the final step of the test is balancing test. That is that the importance of the goal has to be balanced with the extent to which you infringe upon the rights, right? So again, take a contemporary example. I mean, in a pandemic, when you have basically digitized education and medical services, so you can't step out of the house, there's lockdown. Now, you may have very, very powerful interests at stake, but is it permissible to shut down, for example, the internet so that people cannot actually access educational materials, right? Can you have that kind of blanket restriction? That's the question to be asked. So I think that at this four-pronged test, if you apply it rigorously, you will give the government the space to implement very, very important public good policies, while also ensuring that the rights are respected. And that's how I think the transformative kind of vision can balance. Because remember that the transformative vision is not limited to courts. All the bodies, the government, parliament, the courts, must together play a role in implementing that vision. And that can be done, that balance can be found through something like this four-step test.
Thank you, Gautam, for the beautiful answer. Smayappan?
Honorable Justices, respected speaker and learned friends. I would say it was an enlightening session, given the name Gautam and the enlightenment has translated to us. Thank you very much. I would like to only add regarding Article 21, as senior learned advocate had already brought up the issue, and it is regarding the right to education that has been rightly added under Article 21. That is a right to life. They could have added it anywhere, maybe under right to equality, expression, wherever. But they have rightly added it under the right to life, and by which they have extended, the extension of life itself as contemplated in our Constitution. And to that extent, the intention is there is no dearth of laws and intention in our nation, but only when it comes to the implementation of these letters in spirit, where we need a lot of transformation actually. And in that line, you have also touched upon, the internet being accessible to the students, and we cannot, no child should be left behind. And unfortunately, there is a girl of the 11th standard who was suicided because all the classes are going online. And the government has also taken the right step to make it available on the television, where the poverty of the student will not be reflected in the online sessions. And that is the right spirit in which the intention has to translate on the grounds. It's just an observation. And, it's a wonderful session. Thank you very much for organizing it and for translating it to the intention of the Constitution.
Thank you. That's a great point. What I would just add one brief point to that, which is that so I mean, there's often been this clear-cut distinction drawn between civil rights and socioeconomic rights, and that civil rights are there in the Constitution, and socioeconomic rights are rights that the Supreme Court has read into Article 21. Right to food, housing, and so on. I think what this incident and this tragic incident and all of this shows us is actually that these socioeconomic rights are deeply connected with our core civil rights, and in this case, the right to equality. Because once education goes online, and specifically in this context of a pandemic, the access to internet and the access to effective and high-speed internet, which is a question of equality and income and so on, directly impacts the ability to access education. And so I think it's worth thinking about looking at something like the internet as a basic utility, as something like a road or like a water supply that everyone should have access to, because it's become the basis of rights. And looking at it as a question of equality and discrimination, and that there should be no class-based discrimination when it comes to access to this basic infrastructure that makes possible exercise of all your other rights.
Very true, very true. Thank you.
Dr. Sangeeta, Shira?
Hi Gautam, I've had this question for a while, ever since the Article 370 controversy started. Does Article 3 or any other provision of the Constitution give the Parliament the powers to abolish an entire state? Article 3 says you can alter the boundaries, you can diminish a state, but diminish a state to zero and change it into a union territory. In your opinion, of course, the matter is sub judice, but in your opinion, does the Constitution grant that power to the Parliament? Thank you.
I think that's a great question, and this is of course at the core of the case before the Supreme Court. So what I'll do is I'll lay out the two competing views on the issue on interpretation, and you can see what you find more persuasive. So one view, which is the state's view, is that Article 3 is very clear in its language. It allows Parliament to alter, modify, extinguish any state. Parliament can destroy a state, and that includes downgrading a state to a union territory. So so basically Article 3, the text, and if you look at the explanations say that union territory, that state includes union territory for the purposes of this article. So if you just read the text plainly, the argument goes that, look, the state's power, Parliament's power to deal with the states is absolute, and this includes what has been done. That's one argument. The other argument is that there is an implied limitation on what Parliament can do. So if you've seen the recent judgment of the UK Supreme Court in the prorogations case, the question there was that Boris Johnson, the Prime Minister, wanted to get his Brexit deal through without parliamentary scrutiny. So he basically prorogued Parliament for 5 weeks, which is unheard of in the US. That went to Supreme Court, and the UK Supreme Court said that, look, you need to see there are multiple constitutional principles at stake. One is the executive's power to prorogue Parliament. The other equally important constitutional principle is Parliament's right and duty to scrutinize the executive. Now, you cannot use one principle, which is the executive's power, to make the other redundant, right? So if you prorogue Parliament and disable Parliament from scrutinizing what the executive is doing, then the second equally important principle becomes nugatory. It can't happen. And so the court said there's an implied limitation on what the Prime Minister can do. Of course, in India, we have implied limitations in case Gautam Bhatia and those lines of cases. So the other argument is that, look, India is a federation, and the federal structure is part of the basic structure. So you can't. So India cannot be a unitary state. It has to be a federation. That cannot be amended by the Constitution. Now, if Parliament has the power to degrade a state into a union territory, then logically that power extends to all states, and therefore that therefore effectively is a power to turn India from a federation to a unitary state by making every state into a union territory. And so the argument is that there must be an implied limitation upon the power of the Parliament that disables it from accomplishing this kind of an alteration. And therefore, the power to modify boundaries of a state cannot include the power to degrade a state to a union territory, because that would effectively make the federal principle impossible or pointless. And so that's the counter argument. So one argument is based on what you get from the text of Article 3, a simple reading. The other argument is based on a more structural reading of Article 3. And that's what the debate is. There are some links to the petitions which discuss this, and I'll be happy to send them to Surit after this discussion, and he can pass them on, where the argument is set out in some detail. So you can see what the authorities are and what exactly the argument is. But this is a summary of the two competing arguments.
Thank you so much, Gautam. That will be great if you can just pass the material across. Thank you.
Gautam, I can see two questions in the chat box.
Yes.
One question is from Mr. GKP, Karupasamy Pandian from Madurai.
Yes.
He asked the same question in a different way, whether your personal liberty of a person can be denied on the pretext of a pandemic situation.
Yeah, so I think that's a very good and very important question, and there is no easy answer to that. So there is a very interesting Odisha High Court judgment that came out last month, where what they did was they basically had temporarily banned all vehicles, and they were confiscating any vehicles on the road. And so what they said was that, look, if you want to get essential supplies, you need to walk. You need to walk to the store and get it, but you can't use a vehicle. Now, what the Odisha High Court said was, Odisha High Court said, look, imagine disabled people, imagine old people, imagine localities where women may think it's unsafe to go out on foot, and so you can't have this complete ban on movement. You need to carve out exceptions given the situation, and proportionality requires that kind of nuanced analysis that does not support a blanket ban, but only insofar as it is necessary and balanced, right? And so the Odisha High Court said you must allow these categories of people to go in vehicles, ensuring that social distancing, so only two in a vehicle, things like that. So I think that the answer therefore is that yes, of course, to curtail the spread of this pandemic, which literally spreads through contact and through the air, you will obviously have to restrict the liberty of individuals and restrict movement. But that doesn't mean that the restrictions can be senseless or can be disproportionate. So every restriction, whether it's a lockdown or a curfew, you examine that on the lens, touchstone of the proportionality doctrine, and you will find that some will be right and some will be wrong. A very interesting judgment came out from South Africa 2 days ago, the Pretoria High Court, where that court actually struck down their lockdown regulations, and it did so by finding that there was a completely illogical restriction. So, for example, in South Africa, they were allowing 50 people to gather together for, say, a funeral or something else, but they weren't allowing individuals to be out on the beachfront. And so the court said, look, if the whole idea is to stop the spread of the pandemic, this is completely irrational. This makes no sense. So you can examine every individual restriction on a constitutional basis, and you find that some are fine and some are not, depending on the situation.
Thank you, Gautam. There is one more question from one Ms. Selvi. Her question is, she wants to ask whether judicial governance can be part of the transformative constitution.
So I think that this is a complex question, and so I think that the role of governance is something that the executive branch has to do, because that is where the competence to do that lies. I think that the judiciary's role is a proactive role to ensure that the manner in which the governance is being done conforms to constitutional standards, and sometimes this may require a little bit of a push to the government. I think there are some good examples of late. Madras High Court's order on the migrants was a good one. And if you look at the Karnataka High Court's series of orders they've passed recently, also on the migrant workers issue, so it's very interesting. So they began by saying that, look, the lockdown was the result of government action. So the government cannot charge the migrants for going back to the native places. And then the government said, fine, we will not do that. But then it found that only a few of the migrants were being transported back, and large amounts were being left out. Then the court asked the government, why is this happening? And the government said, we have no money. The court said, why don't you look into using disaster relief funds for this purpose? Is it possible? And then the government got back and said, look, it is possible. Then the government said, look, we are sending SMSs to the migrants. And then the court asked, look, how many are receiving those messages? So if you see these orders, you'll find a dialogue going on between the court and the government. The court is not trying to take over governance, but it is asking the government the questions that are required to ensure that that governance takes place in accordance with constitutional rights. So I think the court's role there is to actually create a forum where the government is called upon to justify itself and has to give reasons for what it's doing. And those reasons are insufficient. Then the court steps in and says, look, this is not good enough and you need to do better. And I think that therefore, to answer the question, it's the court effectively acting as a facilitator or a reviewing body that prevents abuses of governance, but not engaging in governance itself.
Gautam, there is one more question by one Mr. Hari Krishnan. He asked you, how do you trace the transformative nature of our constitution with respect to the appointments in higher judicial?
Yeah, so I think that this is of course a much debated question. And I think that if you look at the Constituent Assembly debates, there was the idea of the collegium was not in the minds of the framers, and the word used in Article 124 is consultation. Now, the experience with Indira Gandhi taught us that that system was prone to a certain kind of abuse. And so to insulate itself against that abuse, in 1992, the collegium system was brought into being, which has now been criticized a lot. I think the key issue is that what the Constitution envisages is independence of judiciary and independence from executive dominance. The collegium system and in the NJC judgment, what that judgment holds is that the only way this can be achieved is by judicial primacy in appointments. And I think there's a gap over there because I think there are many different ways in which you can achieve independence of judiciary. In, again, South Africa and Kenya, for example, you have commissions that look into this. A commission that has no executive interference will shortlist, say, 5 names. And then they send these 5 names to the president, and the president picks 3 out of 5. So basically, you don't give the executive a say in the beginning when you're shortlisting your names, but in the end, out of the names you have picked, you give them the final say. So that's one way of kind of, having a balance. So I think there are many different ways and many different models in which you can use to secure independence and appointments and other things. And I think the problem is that in the NJC judgment, they have said that judicial primacy is the only way to do that. I think that's not quite correct. So we need to have a discussion on the manifold ways in which and institutions that can be used to ensure that independence is maintained at the appointment stage, at the post-retirement stage, all of that. And I think there are many models that we can think about, not just the collegium system.
Gautam, there is one more question by Mr. GKP once again. Whether the police officer's power of investigation or duty of a police could be suspended in the name of a pandemic situation. That is a question he has asked.
Yeah, so I should begin by clarifying that I haven't done criminal trial practice for a few years now. So I may not be the best person to answer this question. I think other high courts have also ruled on this issue and in different ways.
Sir. The matter is pending before the Supreme Court.
Exactly. So my own and from what my criminal law colleagues tell me, and this could be I could be wrong. So just to say that. So their opinion seems to be that the statutory bail should be granted because 142 cannot go contrary to a specific statutory provision. So 142 is limited to when there is either absence of statute, but if there is an existing constitutional or statutory provision and there are judgments that say this, then 142 cannot kind of operate to forestall specific statutory terms that are in existence. It can't go contrary to an existing statute.
Mr. Ilangovan.
It's a wonderful presentation.
Thank you.
My question is with regard to the federal system.
Sorry?
See, under the federal system.
Federal system. Yeah.
Yes. At the time of framing the constitution, more power was given to the center. That is to safeguard the infant democracy of India. And they are more concerned with the unity of the nation. Yeah, altogether. Now more than 70 years has been lapsed. It is not the right time for the center to give more autonomy to the state, at least with the legislative powers left to the state as in US and Australia. Now in the case of Jammu Kashmir also, they're completely overtaken by the center. Is not the right time? The state should demand more autonomy.
Yeah, no, I think it's a great question, and I think that I mean you're completely right. There were a lot of proposals during the framing. In fact, there was one proposal, a very interesting proposal, of like a confederation of three of three entities. A lot of what is present day Pakistan, Bengal, and like the rest of India, kind of three confederations that would like come together. So there were many very, very interesting proposals, for distribution of power. And finally, they went with a strong center because they were concerned about the country breaking up into different parts and not surviving as a nation. And I do agree. I think that we need to think about strengthening the federal system, because if you look at all over the world, everywhere, there is a gradual understanding that governance is happens best when it's decentralized, because it is more responsive to the needs of the people who are actually there on the ground. And so the move has always been towards kind of allocating more power to local units, and even in India, the 73rd, 74th amendments, that was the original idea. So I think I agree that and specifically if you see all the recent controversies around fiscal federalism, if you see the whole issue of the allocation of money to different states for fighting COVID, if you see this recent controversy where the central government has said that we will allow states to go beyond the limits of the fiscal deficit limits in the statute, but only if they implement 3 or 4 policies. So I think all of those things are quite reflective of the asymmetrical nature of the federal structure. And I think that this COVID pandemic has shown us that it may be time to think of a more federal, federally oriented system, and that will require, I think, constitutional changes. But I think that as a issue of debate, the time has come to think about that.
Thank you.
The question reads, how do you reconcile the transformative constitution vis-a-vis democracy? What is the relevance of the Constitutional Assembly debates if the interpretation of the Constitution has to be non-originalist?
Yeah, it's a really good question, and so I think the key thing about transformative constitutionalism, it's a method of interpretation of the Constitution that takes seriously a number of different constituting factors. So one of them is the text of the Constitution, because that's the clearest indication of what the Constitution says. The second is the CAD, the debates, because they give you an insight into the context in which the drafting happened. So they are also very, very important. In fact, but I would warn that when you read the debates, it's often very difficult to parse exactly what's happening, because you have all these members of the assembly who have all these views that they articulate in the debates. And in the end, all you have is an up-down vote on provisions. So it becomes quite hard to really decipher the meaning of a constitutional provision from the debates, because this Aditya Nagamma, a scholar, has called it like a polyvocal or polyphonous thing, where you had all these many voices, and it was very hard to see the assembly speaking with one voice on any issue. So I think that's a note of caution over there. But yeah, so text is important, and the framing is important. But what's important equally is to note that the final language of the Constitution, right, is not concrete. It's a little more abstract. So words like equality, right, words like personal liberty, words like life, words like freedom of speech, right, these are all values or principles. They're not something. So if you look at the American Constitution or even the Indian Constitution, age limits upon parliamentarians, you have to be minimum of like 35, 25, whatever, right? That's a very specific provision. But what is liberty, what is freedom, what is equality, and there can be many views on that. Now, what transformative constitutionalism says is to understand the meaning of these really abstract words, you need to go into the history. And the history includes the debates. It includes the pre-constitutional instruments like the Karachi Resolution, where rights were framed. It also includes social movements where people debated these ideas, and these social movements had an impact on the framers themselves, because they were all part of the same milieu. So ultimately, what it does is you have like a broader canon. So you take seriously the debate, you take the text seriously, but you also go beyond that. And to answer the question about originalism, the closest you get is to something what the American scholar Jack Balkin calls framework originalism. So originalism, that you take the origin moment very seriously, but the origin moment is meant to be setting a framework of values when it uses words like equality, freedom, and so on. Putting content into those values is the task of the court. And to do that, you have to go beyond the framing moment, because that doesn't give you the answer, it just gives you the words and sets the framework within which you can engage in your interpretation. Now, as I said, transformative constitutionalism is just one understanding of this history. Now, you may read the history of the framing and the debates and the moments before that, and you may find that actually the Constitution is a conservative document. It was always meant to be conservative. And that's an equally legitimate reading of the history. So ultimately, it's a question of what you think the Constitution was meant to be doing. It could be transformative, it could be conservative. But that reading is based on a number of different factors that include but are not limited to the debates themselves.
Question is asked by Mr. Ram Siddhartha. Thank you, Mr. Ram Siddhartha. So I should thank you wholeheartedly, Gautam. A session which we have been very eagerly waiting, and it's proved to be a very meaningful and elucidating one. And on behalf of everybody, I wholeheartedly thank you for the time and energy you have given. Thanks a lot, Mr.
Thank you so much for inviting me, and I hope to meet some of you in person after pandemic.
And of course, I thank Suhrit for having given the opportunity of bringing you here, and we are very much thankful for Suhrit also. Thank you, Suhrit. Thank you, Gautam. I'm signing off.